dia a todos e todas. Vamos dar início a mais um evento da nossa série International Dialogues in Constitutional Law. Esse é o primeiro evento deste ano. Tinha um evento marcado para março. A gente faz sempre um evento por mês. A gente tinha um evento marcado para março com o professor Carlos Bernal, que é professor na Austrália, na Colômbia, e há mais ou menos um ano é juiz do Tribunal Constitucional da Colômbia. Só que o presidente da corte convocou umas sessões extraordinárias e ele teve que cancelar. Então a gente não teve eventos em março. Estamos começando em abril. Estamos começando também muito bem aqui com Francisco Urbina, da Universidade Católica do Chile. Vou falar umas rápidas palavras. O professor Francisco Urbina é professor de Direito Constitucional, fez seu doutorado em Oxford, tem publicado artigos nas melhores revistas do mundo, Oxford Journal of Legal Studies, Canadian Journal of Jurisprudence. Estou falando tudo de cabeça aqui, não trouxe nenhuma lista. Eu sou como Ronald Rorty, eu falo tudo de improvisação. E tem publicado, então, artigos nas melhores revistas do mundo. Teve o seu livro, sobre o qual ele vai falar aqui hoje, publicado no ano passado pela Cambridge University Press, que é uma crítica ao sopesamento e à proporcionalidade. E recentemente também publicou, em coautoria com alguns autores, um outro livro pela Cambridge University Press chamado Legislated Rights. Quem quiser depois dar uma olhada, está aqui em cima da mesa, mas é meu, não é de ninguém. E ele então vai falar hoje aqui sobre o tema do seu livro sobre proporcionalidade. E o interessante dos nossos eventos é que aqui a gente tem uma pluralidade de opiniões, não só aqueles que concordam com a gente, mas aqueles que discordam da gente também vêm aqui para um debate, às vezes até mais produtivo e mais interessante. Como sempre, a gente vai ter uma exposição de mais ou menos 40, 50 minutos, ou se precisar um pouco mais, não tem problema, a gente tem uma certa liberdade, seguida de um debate até mais ou menos meio-dia, quando todo mundo já vai estar com fome, mas a gente sempre tem bastante tempo para um debate, perguntas do público, e o professor Urbina vai falar, ele tem um certo receio de que o portunhol não seja a língua mais fácil, então ele vai falar em inglês, até porque também eu trabalho em inglês, às vezes quando a gente se enfronha num tema, uma determinada língua, é mais fácil para a gente falar nessa língua, então ele vai falar em inglês, mas as perguntas podem ser, como sempre, nossos eventos podem ser em português, podem ser em espanhol, podem ser em portunhol, podem ser, obviamente, em inglês, ou qualquer outro idioma que a gente possa entender e traduzir, vocês fiquem à vontade. A gente, se precisar, a gente arranja uns tradutores de Swahili, o que quer que seja. E eu, como sempre, vou insistir, isso é assim mesmo, ou seja, não é porque a primeira pessoa fez uma pergunta em inglês, a segunda fez uma pergunta em inglês, a terceira gostaria de fazer uma pergunta, mas acha que o seu inglês não é tão bom. Aqui, qualquer coisa vale. O importante é não ter vergonha de falar. Quem tem que falar, fala e a gente dá um jeito de se fazer entender. Então, antes de passar a palavra definitivamente para o Francisco, agradecer também ao Conrado, que é o organizador desses nossos eventos, agradecer a presença de vocês e de alguns professores. Vejo aqui, eu tenho que fazer um mapeamento. Professor Rafael Maffei, professor José Reinaldo Lima Lopes, do Departamento de Teoria do Direito, professor Estevão Malê, do Departamento de Direito do Trabalho. Se eu tiver esquecido de alguém, vocês me perdoem. E obrigado a todos e todos. E já aproveitando, antes que eu me esqueça, avisar que no dia 10 de maio, a gente tem o nosso evento de maio, com o professor Udo de Fábio, da Universidade de Bonn, na Alemanha, ex-juiz do Tribunal Constitucional da Alemanha, que vai falar sobre partidos políticos, financiamento e outras questões bastante atuais para o mundo inteiro, especificamente para o Brasil. Então, Francisco, muito obrigado por ter aceitado participar, obrigado pela presença. Agora é com você. Obrigado.
Sorry for not speaking your language, and I've since realized that most of you speak Spanish very well, so maybe I should have prepared for something in Spanish. I thought about doing it in English to make sure I could express myself more accurately, but of course I like the idea of if I understood it correctly, todo vale. I like that. So then later, just asking should it in whatever language or whatever way you prefer. Um, so many thanks to Professor Virgílio da Silva and Conrado Hübner Mendes, and to the Faculty of Law of Sao Paulo University for inviting me to participate in these dialogues in constitutional law. And thanks to all of you for coming today. I know there is fierce competition for the activities, and John Tasiulas is in a different room. I'm going to quote him later. So this is one of those like big festivals like Lollapalooza or where all these important bands, and then there's one band less important, but I'm very, very happy that you'll come here today. Thank you very much. The talk is entitled A Critique of Proportionality and Balancing. Is the same title of the book. So you see, I'm not very creative when it comes to titles. It's exactly what I intend to do, right? So what I will try to do is give a sense of some of the problems that I see in the use of proportionality in the context of fundamental rights, and I'll try to provide a succinct version of some of the arguments that I advance in the book. Now, it'll be useful to start with some clarifications. I do not challenge all uses of proportionality in law. Of course, I have nothing against the idea that punishment must be proportional to the crime, for example. What I wish to challenge is a specific method for evaluating so-called limitations or interferences with human or constitutional rights. This method is used now all around the world by courts adjudicating such rights. I understand it's used here in Brazil as well. It's also in my country, but in many other places. And I think this method will be known to most of you or to many of you. It is commonly formulated as a 4-part test used in cases regarding a limitation or interference with a human right. In such cases, courts commonly address the issue in 2 steps. In step 1, courts inquire whether there has been an interference with the human rights. Because at this stage, the scope of the right is usually taken to be very broad, this step is not specially demanding, and courts commonly find that there has been, indeed, an interference with a right. In step 2, courts evaluate whether this limitation is justified. To determine this, they apply the principle of proportionality, or also called proportionality test. This test can be best formulated as comprising 4 subtests. The first subtest asks whether the interference pursues a legitimate aim or an aim of sufficient importance. The second, whether the measure under review is apt to achieve that aim. The third, whether there are no less burdensome alternatives. And the fourth, and I will be intentionally vague in formulating this at this point, ask whether the burden to the right holder is not disproportionate or does not outweigh the realization of the public good or rights sought by the measure. It is this last subtest, balancing, the one that is taken to be more prominent and characteristic of the test. Though there are different formulations of the proportionality test and of each of the subtests, I will focus here on this full 4-pronged formulation, and especially on balancing as the more characteristic part. Now, one difficulty of any normative engagement with the proportionality test is that it can seem to be a bit of a moving target. So Richard Eakins has noticed that when it is argued that the test is excessively technical and consequentialist, sometimes it is replied that it is of great flexibility, allowing all kinds of moral reasoning. When it is objected in turn that it's very flexible and allows for excessive judicial discretion, sometimes it is replied that it is technical and structural. But it can surely be both. If one pays close attention to some of the more prominent writings of proportionality in fundamental rights law, I believe one finds 2 different conceptions of proportionality, each one with its own justification for proportionality and with distinct advantages and disadvantages. Of course, it is entirely possible that a court or a theorist trades on the ambiguity of the proportionality test and uses proportionality in a way that it is ambiguous between the 2. We have sometimes this problem with courts, especially, so it's not so clear where they fall. But if one were to provide a normative justification for the test, and be rigorous in applying that which one justified, I think what would end with one of the two conceptions that I had identified here. But it's, of course, an open question whether there are more that you would like to discuss. The conceptions are in important respects mutually exclusive. The main alternative is what I call the maximization account of proportionality, which is the more prominent, and I think it's the more theoretically rich version. The second, I call proportionality as legally unconstrained reasoning, and it's achieving increasing influence, especially in the sort of English-speaking world. The fact that they're mutually exclusive will become apparent, I think, I hope, when I explain these two conceptions, but let me say just this in advance. At the level of the normative assessment of each conception, it is easy to see that they have different and mutually exclusive advantages. One stresses the fact that it yields relatively clear answers in the cases to which it is applied. It is not open-ended and provides a clear method. The other one, on the contrary, allows for any form of practical reasoning that is relevant in the case. But if the former is to provide real guidance, it surely is because it picks up one specific form of practical reasoning to which it commits itself. And if the latter is to be as flexible as it claims, it must be because it is agnostic in this respect. Now, one cannot be a believer and an agnostic with regard to the same thing and in the same respect. The test cannot be as determined and defined as it is according to the first conception, and at the same time as open and flexible as it is according to the second. Hence the reasons for me to separate the two. Let me start with the first conception then, which I think very aptly expresses the deeper logic of proportionality, law, and practice. Courts often refer to proportionality cases as requiring of them a determination of whether, and this is a quotation, a fair balance was struck between the competing interests of the individuals that challenge a state measure and the community as a whole. Thus, for example, in the context of euthanasia and assisted suicide, Lord Neuberger of the United Kingdom Supreme Court recalled that the Strasbourg Court explained that when considering legislation on assisted suicide, one has to balance the Article 8.1 rights of those who wish to be assisted against the need to protect the weak and vulnerable in relation to the Article 2 and Article 8.1 rights. The Canadian Supreme Court speaks of its proportionality assessment under Section 1 of the Canadian Charter of Rights and Freedoms as aimed at determining whether the public good justifies depriving an individual of, for example, life, liberty, or the security of the person, the rights established in Section 7 of the Canadian Charter. In fact, many times, courts speak of proportionality analysis as involving the assessment of competing social interests or of competing public and private interests, an expression used by the European Court of Human Rights, for example. The balancing stage is generally thought of as the most important and characteristic stage of proportionality, the very heart of proportionality, as a leading commentator puts it. This prominence is also suggested by the fact that this subtest is often referred to as proportionality stricto sensu. This is as a characteristic or paradigmatic part that takes the name of the whole. It is at the balancing stage where the competing public and private interests will be weighed. Now, weighing here is a metaphor. But it is a metaphor for what? Some judicial formulations of the last balancing subtests are notoriously tautological. The measure would fail the proportionality stricto sensu subtest if there is no proportionality between the effects of the measures which are responsible for limiting the right and the objective which has been identified as of sufficient importance. So this last formulation is from the well-known Canadian Oakes test, which is the one that formulated the proportionality requirements in Canadian constitutional law, but also has been important to many common law jurisdictions. So it's considered a very influential case. Yet other formulations are more informative, pointing to the fact that what balancing entails is some kind of quantitative comparison, a comparison in terms such as more, less, or equal, of the costs of the measure for the affected right and the benefits in terms of its public aim, such that the benefits must at least be equal to the costs, or as Julian River puts it, it must be the case that the gain to the public interest at least balances out the cost to the right. In the influential Canadian Oakes case that we just mentioned, for example, the court explains that what the balancing subtest requires is that the more severe the deleterious effects of a measure, the more important the objectives must be. There has to be at least some kind of equivalence in the magnitude of the two. Similar statements can be found in decisions in other jurisdictions. Some leading commentators suggest that balancing is concerned with whether there is a net gain in the measure under review, or whether the measure maximized interests, satisfaction, or principle or value realization, as David Beatty and Robert Alexie respectively conceive of the balancing exercise and of proportionality in general. So under a prominent conception of proportionality analysis, the costs incurred on the side of the right are justified if they're compensated by sufficient gains in terms of the realization of the legitimate aim or measure, or as Alexis says, the permissible level of non-satisfaction of or detriment to one principle depends on the importance of satisfying the other. Now, it seems to me that there are a number of problems with this way of addressing human rights cases, and this is more or less the claim of a part of the book. The first is that it's not clear how these two very different magnitudes, namely the burden on a right and the gains in terms of some public interest on another right, can be compared and balanced quantitatively. This is the problem of incommensurability. In a nutshell, the claim here is that these different considerations, say the realization of a fundamental right and of another fundamental right or fundamental right and a public good, cannot be compared quantitatively, and thus it cannot be said that the realization of a right is somehow more than or equal to the non-realization of another right or public good. This, of course, does not entail that it is always necessarily impossible or unreasonable to choose to realize one right rather than another right or a public good. It may well be possible and reasonable to do so. It is simply the case that this choice cannot be justified in a quantitative comparison of the levels of satisfaction of the relevant rights and public goods. Now, I do not want to delve into the details of incommensurability. Professor Da Silva has offered perhaps the most influential analysis of incommensurability and proportionality. I tried to address some of his challenges in my book. I don't know if successfully, but I did my best. And incommensurability is a tricky topic. I'm always doubtful whether I was right to include it in the book or not. I suspect I lose lots of the readers when I in that chapter on incommensurability, which is kind of long-winded effort at sort of engaging with different complexities of it. So what I would like to do here, instead of going through all that, is I would like to take a step back and highlight an important aspect of the debate that I think has been brought to light by more recent contributions to these specific questions. And this is kind of some tentative thoughts raised by some recent literature. So Cristóbal Caviedes, in a recent paper in the American Journal of Jurisprudence, applies Ruth Chang's theory of practical reason to the question of incommensurability. Now, to summarize, Chang's theory is that beyond the well-known value relations of better than, worse than, or equally good, there is a fourth possible value relation, which she calls on a par. As Caviedes puts it, items are on a par provided that, although comparable, neither is better than the other, nor they are equal with respect to the covering value. This would be significant for debates on incommensurability because, on this theory, many cases of purported incommensurability, or what Chang calls incomparability, though I avoid that term, would be cases where really the alternatives are on a par, so they're not really incommensurable but on a par. Now, I'm not sure this is actually so, and I'm not going to go into the details of the difference between incommensurability and a par. It's kind of we can discuss it in the discussions. But what I'm more interested is in Caviedes' conclusion, which is the following: even if we were to reject the incommensurability objection to proportionality because of the possibility of parity, so things are not necessarily incommensurable, but they can be said to be on a par, so they can be in some sense compared. This would leave proportionality no better. The reason for this is that if the alternatives are on a par, then there is no conclusive reason to choose one or the other, and thus no reason for a court reviewing the decision of a primary decision maker to think of it as somewhat disproportionate. This element I would like to flesh out. Now, what is interesting of these new developments, I think, is that they highlight two key elements. The first is the relevance of rational underdeterminacy. What parity and incommensurability have in common is that they're both sources of rational underdeterminacy. When parity or incommensurability are present in a choice situation, there will be no single reasonable alternative to choose. This is what I mean by rational underdeterminacy. There's no one right alternative. The second key element is crucial for understanding why rational underdeterminacy matters in this context. This key element is the institutional context of proportionality. In talking about proportionality test in law, we're talking primarily about a judicial method used in the review of the actions of a primary decision maker, typically the administrator or legislature. Now, in setting up a system of review of a certain choice, it is presupposed that at least some aspects of the choice are rationally determined, and thus that it is possible to choose wrongly or mistakenly with regard to those aspects. Thus, in the simplest scenario, we have two decision makers, a primary decision maker, which makes the choice in the first place, and a secondary decision maker who evaluates whether the choice of the primary decision maker was the right one, and who has authority to either replace the choice of the primary decision maker when it deems that he erred, or to somehow compel the primary decision maker to change its original choice or adopt measures to correct it. It would not make sense to have a secondary decision maker if the choice was undetermined and any choice were as good as the other. The point here is that whether fundamental rights decisions involving commensurability or parity, the upshot is similar in this regard. Both incommensurability and parity are sources of rational underdeterminacy. If the method a court should use to evaluate a decision of a primary decision maker is oriented towards determining if the realization of the legitimate aim entailed by such decision is less than what is lost on the side of the affected right, then both incommensurability and parity will dictate a similar result, namely that the benefit and the loss are such that any attempt at comparing the quantities of these items will end up allowing discretion to the primary decision maker. Incommensurability claims that proportionality as maximization fails because it demands courts to undertake a comparison that cannot be undertaken. A choice can be made for sure, but the relative quantities of realization of opposing rights and public goods do not provide a conclusive reason either way. Thus, while a decision by a primary decision maker may still be justified, a revision of a secondary decision maker in terms of whether the primary decision achieved the right balance in quantitative terms is not warranted. Parity arrives at a similar result. If the rights and public goods at stake are on a par, based on whether the degrees of realization of the further right or public good match up to the degrees of non-realization of the affected right. This is because if the terms of comparison are on a par, the decision is underdetermined in that respect, and thus it makes little sense to have a system for reviewing them based precisely on the kind of comparison that will show them to be on a par. I do not want to say that if one adopts the idea of incommensurability or of parity, then one is committed to the idea that whatever measure is adopted by the primary decision maker, this measure is not open to a rational challenge, and review of it is unwarranted, is always unwarranted. I don't want to say that. The claim is directed against a specific method for assessing the value of such a measure, one that compares the levels of satisfaction or non-satisfaction, realization or non-realization, of the different rights and public goods at stake. For the incommensurability objection, the one I leveled, this comparison will yield that they are incommensurable. And if there is a good in the satisfaction of all the items at stake, then there is in principle discretion to choose any of them. The same occurs with regard to parity. From this perspective, it would make little sense to have a method of review that precisely focuses on such features of the choice according to which the choice appears as underdetermined and thus as granting, in that regard, discretion to the primary decision maker. Now, that's all I want to say about incommensurability and parity, which is kind of a difficult topic. But it pays to pay attention to this question of incommensurability. And relevant as it is, it seems to me it's not the main object of a critique of proportionality as maximization. For me, the main issue is the question of rights. And it's the main issue because it's the one that features more prominently in a further later constructive approach. So once one has rejected proportionality, what comes next? I mean, in thinking about that, which I haven't figured out yet, obviously, at this point, but in thinking about that, the idea of rights features more prominently than the idea of incommensurability. So I think the question of rights is the kind of more prominent one, and this is the one I will address now. Beyond incommensurability, critics of proportionality have raised the following objection: that the idea that one is to choose between different alternatives based on some form of quantitative balancing of costs and benefits is alien to rights. Determining the intensity and extension of the interest on the different sides of the equation is different from determining what is each person's due. What is it that the parties are entitled to as a matter of their rights? These are two different and distinct ways of thinking, or so I argue. Quantitative balancing is oriented towards some form of maximization, towards achieving net benefits or at least avoiding net losses. This way of addressing a choice is pertinent when we are thinking about the good of only one person, for whom some alternative will have some costs and some benefits, and a different alternative will have different costs and benefits. It makes sense, I don't say it's possible, but it makes sense to think that an alternative that entails some sacrifice for this person is reasonable if it entails greater benefits for this same person, and unreasonable if the costs are greater. But things are more complicated if more than one person is involved. Here the sacrifice does not necessarily fall, or falls not only, in the person that benefits from a specific measure. So there's a distribution question. It is deeply problematic then to trade off the sacrifices in some people against the benefits for others. The reason why this is problematic, I think, has been well expressed by John Tasiulas, who is talking in the neighboring room. Tasiulas says, if human beings matter in themselves as sources of ultimate moral concern, each potentially with their own life to lead, then it is a travesty simply to detach their interest from them with a view to maximizing the overall fulfillment of interest across persons. The individuals with this interest count in themselves, and not because the satisfaction or frustration of their interest is ultimately assimilated to some overarching aggregative concern. Here there will be conflicts of interest between different persons, and the question then is, how do these people stand to each other in this respect? These are questions of right and justice. How do we stand in relation to each other? Rights reasoning is oriented towards establishing what is each person's due, what each person is entitled to as a matter of rights. It is keenly sensitive to the separation of persons. Hence the special force that rights are taken to have, and which makes them relatively immune to trade-offs. Take, for example, cases involving euthanasia and assisted suicide. In these cases such as the Pretty case in the European Court of Human Rights, or such as Nicholson and Conway in the United Kingdom, the court would frame the issue as concerning an interference with the right to private life in Article 8 of the European Convention on Human Rights. The question then is whether this interference is justified under Article 8.2. In determining this, the court will resort to proportionality reasoning, evaluating ultimately whether the interference with the right is justified by the attainment of the legitimate aim. Thus, in Pretty, the European Court says that the more serious the harm involved, the more heavily will weigh in the balance of considerations of public health and safety against the countervailing principle of personal autonomy. Now, if the reasons for and against euthanasia-assisted suicide were purely consequence-based, then there would be nothing problematic in the balancing framing of the issue. If rights are not at stake, then there is no deficiency in not assessing rights. But there would be a deficiency in conveying the misleading impression that these are human rights cases. But many arguments in the euthanasia debate, and perhaps the more influential ones on both sides of the debate, are not consequentialist. Some focus on the inalienability of the right to life, or on the strength and scope of a right to make end-of-life decision. Others are dermatological in structure, pointing to our duties not to perform certain types of actions, such that it would be always wrong to intentionally kill another human being, and thus there can be no right to euthanasia or assisted suicide. So these are arguments that are made on both sides of the debate. Now, none of these types of reason are aptly captured in the balancing weighing method to which proportionality decisions purport to commit themselves. My claims that balancing reasoning and rights reasoning are distinct ways of addressing a choice situation. To the extent that one engages in one form of reasoning, the other form of reasoning is not featured in deliberation. To the extent that one form of reasoning is controlling of a decision, the other one will not be. And to the extent that proportionality analysis engages in the first form of reasoning, the second, rights reasoning, will be moved out of the picture. Thus, it is no surprise that, as some commentators have noticed, the special normative force that is often attributed to rights in moral and legal discourse is also lost in proportionality analysis. The interest purportedly protected by human rights can be legitimately interfered with to a substantial degree, as long as the benefits deriving from that interference are important enough. They can also feature as mere legitimate aims of state action, again, as aims that can be traded off against other interests interfered with by the measure. Rights here seen more as interests or values, and they do neither trump nor possess lexical priority nor serve as side constraints, which are usually ways in which the force of rights is captured in moral or legal theory. All this, it seems to me, entails losing sight of some relevant moral distinctions. If there are certain particularly stringent requirements of justice that ground certain claims that everybody has in virtue of being human, then proportionality analysis fails by not considering the particular force that these claims have in the domain of fundamental rights. This is candidly acknowledged by David Beatty when he claims that proportionality makes the concepts of right almost irrelevant, so this is a quotation, and that rights have no special force as trumps, being mere rhetorical flourish. Those are his words. It is also suggested by the fact that courts applying proportionality often talk of assessing interests or sometimes values rather than rights. Thus, courts often refer to the balancing of interests required under the Human Rights Convention, for example, common term, or to the tasks of the court in performing the proportionality test as one of balancing the applicant's individual interest against the public interest, or talk of what in some legal documents appears textually as a right in terms of an interest, thus referring, for example, to the private life interest of an applicant instead of to his right to private and family life. Nothing of this is conclusive, but I think it's kind of an indication in the language of courts that there's something lost in terms of grappling with these concepts as rights rather than as interests or values. Some defenders of proportionality have sought to address this problem by taking advantage of the relatively vague formulation of the test. And here enter the second conception of proportionality. Proportionality, they suggest, could be understood simply as a tool for demanding justification from government authorities and to assess their reasons through direct moral or prudential deliberation, where all relevant considerations can be assessed. In this sense, the balancing subtest in proportionality would require nothing precise, not maximization, not analysis of whether the non-satisfaction of principle is somehow compensated by the satisfaction of the other, but simply to balance reasons in the sense of assessing reasons for and against a particular decision, and choosing based on the most reasonable engagement with the relevant considerations. This is the second conception of proportionality, and one which has gained influence in the last years. It is a conception where proportionality is not aimed at maximization and quantitative comparisons, but rather allows for whatever moral reasoning is appropriate, unconstrained by legal categories. Yet this conception relies on and exacerbates what I think is already a troublesome feature of proportionality. It can be asked then whether proportionality is an apt legal tool suitable for judicial use. At the crucial balancing stage, it would provide, on this account, not on the other account, no guidance as to how to perform this complex exercise. As a result, judicial determinations of balancing are commonly accused of being often impressionistic, opaque, or of there being a gap between the statement of different interests to be weighed and the conclusion as to the proportionality or disproportionality of a measure. Discretion comes at a price, the price of lack of legal guidance. In thinking about this, I think it's important to hold in mind the advantages of positive law and of legal direction in the first place, of having general and public standards that bear on our choices, constrain our decisions, and guide our behavior, and in particular the behavior of lawyers and judges. Here I cannot address this topic in any detail, but some suggestion can shed light on proportionality and its alternatives. There are at least three advantages to positive authoritative settlement of certain matters by positive law. Such authoritative settlement provides epistemic guidance as to what to do in a choice situation. It allows for social coordination, and it limits discretion of decision makers in contexts where such limitation would be desirable. These benefits are available as well for legal adjudication. Judges face complex moral and factual questions which they need to resolve under severe constraints of time and resources. The epistemic guidance provided by the body of law that applies to the issue can be an important aid for judges in bringing order to the issues raised by the parties and making a reasonable decision. Because we do not have Hercules sitting in the bench or as a lawyer, this epistemic help is useful for human judges and lawyers working under severe constraints. When there is a body of rules that applies to the case, which judges apply faithfully, this also allows for different courts to coordinate around a similar approach, which diminishes the possibility and extent to which the decision of one's case depends on the merely contingent and morally relevant fact of who is the judge that was appointed to hear the case. Finally, such a body of rules bearing on the case imposes a limit to the discretion of judges. This is healthy for the parties that do not see their cases depending on the unbound will of another individual, but it is not only healthy for the parties, but at least to an important extent, it is also helpful for the impartiality of justice and for the respect to the judicial system. It is also useful for judges because it allows them to divert responsibility for the judgment to an external standard, thus deviating some of the pressure that public opinion, some party, or some other group with a stake in the decision may be exerting, promoting in turn judicial independence. Note that these benefits do not consist in mere rule of law concern with certainty and predictability, so it's not just formal values such as certainty, predictability. The epistemic and pressure-reducing benefits of legal direction increase the likelihood that judges will decide based on the true moral rights at stake. The coordination benefits achieve not only certainty, but also fairness and equality, in that people in similar situations are treated similarly. Or at least that's the claim I push in the book and elsewhere. Now, these are all surely substantive values, which go beyond concern for so-called formal values related to a thin version of the rule of law. They go to the core of what we expect of the judicial function, the fair, independent, and stable administration of justice, and the justice and conformity to law of the decisions of the courts. Of course, the guidance offered by the law cannot and should not be total. But in developed legal system, it is often substantial. This is something that law students know better than anyone, especially as the exams approach. The law is not only about books, but it's about big books. So when you approach an exam, you have usually in constitutional law like a big amount of pages that you have to memorize, a code, a case book in common law doctrines. That means a substantial amount of rules that relate to the issues. So not just a few principles that could be applied, but a substantial amount of rules and legal categories, definitions, and like that's kind of the normal operation of the law, and that's why it takes a time to master it. For law to provide its advantages to adjudication, it has to be able to guide action so as to order human affairs. This requires fulfillment of the well-known desiderata, explained by Lon Fuller and others, that laws be general, prospective, possible to comply with, clear, stable, coherent, etc. In particular, it requires that rules actually define some course of action to be followed, even if they don't define it exhaustively. To the extent that proportionality could consist in a rights-based way of reasoning, it will do so at the expense of exploiting its legally unrestrained character, relinquishing the important advantages that legal direction offers to adjudication. Now, the argument which I have tried to sketch here, and that I develop more fully in the book, though if I did my job well, maybe you will not have to read it, is that proportionality is not what it should be. It is either deficient at the moral level by addressing conflicts without regard to important, decisive moral considerations, rights, or it is also deficient at the technical level by providing scant legal direction in addressing human rights issues, and sometimes both. Proper legal direction would offer the needed guidance regarding the relevant moral and prudential considerations at stake in different types of human rights cases, and how they should be related so as to arrive at a decision in the case. This gives us some indication as to the alternative to proportionality, which the book tries to articulate in the last chapter, but that here I can only hint at. Because the relevant moral and prudential considerations at stake in different kinds of cases are different, such that relevant considerations in thinking about rights and duties in terms of, for example, religious liberty, are not necessarily the same that what is relevant in terms of, for example, due process. Legal rules that attempt to give expression to such considerations will be diverse. We should expect law in human rights to be what it actually is generally in most areas in developed legal system. This is a complex and rich body of rules, rules which are precise, specific, and diverse. Different definitions, prescriptions, and tests applying to different types of human or fundamental rights issues. To put it simply, not one test to rule them all, but many. Thank you very much.
Muchas gracias. Thank you. I don't know what should I to speak in English. No problem. No problem at all. As you said, todo vale. Obrigado, Francisco, pelas provocações, pela exposição, pela provocação. No Brasil existe um certo sentimento, a gente acompanha a jurisprudência do Supremo Tribunal Federal, muito do que você falou passa pela mente das pessoas, pouca segurança, muita abertura, pouca regra, muito sopesamento. Então, acho que isso é uma provocação bastante relevante. Eu queria também agradecer a presença de mais gente aqui, mais professores, o professor Humberto Ávila, que tem bastante trabalho sobre ponderação e proporcionalidade, e o Denis Antoniali também. E já abri direto de novo para as perguntas, em qualquer idioma, todo vale. E só antes de falar rapidamente, como você falou que você não é muito bom de títulos, eu inadvertidamente inverti as palavras. Então, na palestra ficou balancing proportionality ao invés de proportionality and balancing, so it's a change. It's a change of title. Então, por favor, gente, à vontade para as perguntas. Eu tenho umas 37, mas eu deixo para depois. I have 37 questions. Yeah. Gente, precisam ficar tímidos. Vou começar a fazer perguntas. Então, eu vou começar. Eu vou fazer uma pergunta, enquanto isso as pessoas perdem a timidez. No problem at all. No, you're not. You're not. I would like to ask you to say two things and then ask you a question. The first thing has to do with what you said in the end about learning for exams in big books. There's no rule a magic rule that otherwise, why are we writing so many books if I have proportionality? It's enough. And there's a former judge of the German Constitutional Court that said something similar. Birkenfeld also was a strong objections against proportionality. He said, well, when I give exams to my students and they will apply the proportionality and then arrive to the final test balancing, and then the students know now I get the higher note, but nothing is wrong. So I'm balancing them and my answer is right. So eu tenho razão em qualquer coisa desde que eu pondere. Yeah, no, but isso não vale nas minhas provas. No. And the second thing, it's unfortunately you don't mention here the Judge Berta. It's one of the most my students love. The Judge Berta. It's a one chapter of the book mentioned a judge that has no background, legal background, no rules, nothing, just deciding cases from scratch. I don't have rules. I don't have standards. I know nothing about law, but I'm very reasonable person, and maybe I can do justice, but maybe not. But I would like to ask you a question. First one, I'll choose. Well, okay. Let's assume that I can't use balancing or proportionality to decide cases involving fundamental rights. So I have to decide what rights at stake really protect. So let me see Article 5, fourth clause of the Brazilian Constitution, freedom of expression. Simply state, é livre a manifestação do pensamento. The second clause about anonymity, but it's not relevant, no. É livre a manifestação do pensamento. What is actually free here? What can I say and what can't? Without recurring to proportionality, because my point is, yeah, I agree. I need the right grammar, and I'm talking about rights and not interests and values. But if I only say, well, the core is protected and only this, it's not enough. So I would like to. It's actually a question about the end. What is the alternative? But I think it maybe.
So it's a great question. I mean, that's kind of the part of the challenge, right? Of my book. So let me just make as an introductory remark. So when I presented this in Oxford, so John Finnis asked like a similar question with the following idea. Say, well, human rights documents or fundamental rights documents are already vague, which is kind of what you're mentioning in regard to the Brazilian court. That's the text we have. We cannot improve on it, or we cannot change it, right? Like the judge normally cannot. So could courts have done differently, or how, right? So what should be? and it's a difficult question because it raises questions as well of legal powers and like, right. So in which powers do courts have here are maybe are different from what the powers they would have in other places, and so it's different what they can do and what they cannot. But let me just kind of offer a tentative answer to this. So let me just say something first about Judge Berta. So you mentioned, like, just to kind of introduce the topic and sort of to convey my general outlook of that. So there's one. So that I present two views of proportionality. There's one. So the one that's kind of more maximization like. I think that one does not have these sort of problems because if it at least it aspires to provide a sort of determinate. Exactly. Right. It's my favorite one. It aspires to provide a more determinate. Right. So this comes so this engagement with sort of, now in practice it may not be like that. So then some of the issues I raise in regarding to the other conception may be relevant to the practice, right? But my argument against sort of full discretion and open-ended sort of legal clauses and tests applies more to the second theory, which it's very interesting how it starts more or less claiming that proportionality could be seen as some kind of opportunity sort of window to engage in open-ended reasoning about whatever it's right to the case. And from there, very quickly, so for example, Kai Moller very quickly realizes, well, actually, if we're going to have that, then we don't even need these kind of vague clauses like freedom of expression, freedom of... So not even that, right? Because if we're going to understand that in proportionality terms, and in the end we're going to just engage with whatever moral justification is really at issue in the case, then maybe we don't even need, not even the scant, briefly formulated set of rights. Maybe we just need one thing that says, state measures should be proportional or something like that. And I understand Jamal Green has kind of been pushing something like that similarly in the US. So it kind of calls into question there's this tendency, so to say, to consolidation of the diversity of legal materials into one thing, which is very open and broad. And my interest is in moving exactly in the other direction. So more legal materials and plurality and materials that are more defined. And that is because I think legal adjudication and generally kind of order through law requires specificity. And so here's where the thought experiment of Judge Berta comes in. It is, I don't present it like that, but it's in a way some kind of dialogue with sort of Ronald Dworkin's Hercules, right? So if one's thinking about Hercules, maybe you're familiar with. So Dworkin, in explaining his theory of interpretation, very famously thought about a superhuman judge of infinite knowledge, time, and capacities, which he called Hercules. And Hercules is a device that helps Dworkin, and I'm not challenging that, of course, but it helps Dworkin think about what would be sort of very, very good interpretation, right? So then he can kind of understand how interpretation works and the like. And I think it's useful for that purpose to think about Hercules, but it is also useful to think about what would be a judge that is not Hercules, and what sort of tools does the judge need to adjudicate well. So for that, I think about of Berta. So my example is one of one of those scenarios of a shipwreck. So there are some survivors in an island. This is kind of like Lost. I don't know if you saw the series, kind of that sort of thing. But there's no lawyer, which for some people that would be very fortunate, right? Like we got a doctor, we got an engineer, and there's no lawyer. So it's kind of like a perfect utopia. But it's not like that. It's not like that. So this is kind of my right. There's no lawyer, so they name someone that I don't know if I say it. I imagine Bert as a nurse. So I imagine someone that was smart and thoughtful. So she's like smart and tries to do good, because you could have a smart evil judge, right? That's possible too. That's worse. But this is kind of a thoughtful person, really cares about the people, cares about the issues, and she's smart, but she's not Hercules, right? And she knows nothing of law, and no one in the island knows nothing of law. So there's no legal tradition that you can sort of bring in. And so my thought experiment tries to convey this, which is something that maybe when at least it was my experience when going to doing practice for the first time, which is that if you talk sometimes to lay people meaning not lawyers, sometimes they will tell you the facts that occur to them, but they will give you all this information about, my neighbor painted the wall that was and threw some painting to my side, and he's always looking me badly with this and never says hello when I say hello as well. So there's all this information that is kind of mixed, and he crashed my car the other day as well, so that's another thing. And as a lawyer, we kind of find it relatively easy sometimes to sort of set up things, and part of our job is to divide these things and say, okay, well, this is relevant, this is not relevant. Whether he looked at you, well, that doesn't matter. The painting thing, well, that's relevant because there may be some responsibility for that, some civil responsibility for that. Now, if he threatened you with a knife, no, that's another thing. It doesn't go in the same reason, where the threat will assess it in a different thing. And so from one thing we apply the legal categories of criminal law, in others we apply contract law, in others we apply. That comes naturally for us as lawyers, but it's not natural. There's nothing natural about it. And if one looks at, say, less for what one would have called earlier on a primitive legal system. So Max Weber, for example, sometimes explores less developed legal system, and many times they mix these things in ways that we would think are not reasonable. These are disobey to different considerations. So it's kind of I think some sort of cultural achievement to have a body of law that you can apply to the case. My favorite part in the book is actually a footnote. It's a long footnote in that chapter where I mentioned some article that appears in the New York Times. I don't know if you noticed that. So there's a story in the New York Times about lay judges in outside New York City. So this is, very, I don't know, urban area, very developed country and so on. But they have these judges that are not professionals, and they adjudicate normal cases. And the results, as the New York Times presents in a series of papers, because the results are atrocious. You have a judge that someone comes to complain to him about some cattle that is, and so the judge goes and immediately sends the person that is being accused, that is being complained against, to the jail of the county. So it calls the chairman immediately to jail until he recognizes what he did. And then and there are a number of other cases like that, or a judge gets a complaint, and so because he knows and he's a friend of the person that was complaining about, he goes and talks to his friend, and the friend says, no, there's no issue here, it's just this guy that's always complaining. Okay, that's okay, well, case closed. And it's like a private conversation between the judge, where like every law student knows, even if you don't remember your procedural law classes, which is my case, I don't remember anything of procedural law, but I know you cannot do that, right? So lawyers kind of have a sense of that. But the results are atrocious. So I want to make Berta smart enough to be troubled, smart enough to be confused. That's what you would expect of someone that it's reasonably competent and thoughtful, to receive these cases, receive the different cases that arise, and realize that they're very difficult, they're complex, they raise conflicting considerations, that people in society will perceive them different ways, and she will withstand some pressure of some people that will not be happy with her ruling, and she will know that she has to deal with the different arguments that are being thrown at her, and needs to find ways of ordering that, and so on. So this is difficult, and Berta has little time. So this is a difference, a big difference, I think, that judges have with Hercules and with academics as well. So we academics, we can think about one problem for many years. And it's easy for us to forget that judges have to decide with limited time. So even if they're very smart, they cannot spend a lot of time doing all the research necessary to achieve this case. So you have to have something. So I think a body of law, even though it's imperfect, and we know that there's problem with our judicial systems, but even if it's perfect, it gives big advantage to have that, to have a body of law that will help you order things. And it has a range of advantages. So it helps you, it gives guidance, but it also helps coordination. Coordination is very important for the reasons of fairness I mentioned here and other reasons. Helps the judge withstand the pressure. That's important as well. For example, in criminal law, I think it's tremendously important, and so on, right? The rule of law and considerations and the like. So let me just, so that's my way of saying that. That's why I like that there is a body of sort of specific of norms of certain specificity that can actually give some guidance to the judge. If the norms are relatively specific, and this is what ties with the kind of a human constitutional law considerations and the right. If the norms are relatively specific, then they will have to be different for different types of situation, because the moral and prudential considerations at stake in different cases are different. So only at the greatest level of generality one can say, well, proportionality is involved in everything. Or one can say, well, the principle of good faith is involved in many things. But if you want to be more specific, well, the problems related to freedom of religion, that raises questions, for example, of accommodation, of official state religion, and other things like that, are different from the issues that arise from freedom of expression or the like. So we should expect a body of rules that are different. Now, that's a very long introduction to get to the question. So what would I do? What would be my account? I think it's, I mean, in when I get asked this question, I mean, when I got asked this question in England, I took advantage of the fact that common law reasoning is kind of familiar to them. So you can use, I mean, you can use the normal tools of the common law in the case of a judge there with those powers. You can use the tools of the common law to provide a specification, right? So you will have to define what is expression, you would have to define what is freedom, and you would try to craft precise rules. Now, how you do that? Well, you will have to do it initially through some kind of moral, open, and political reason of the kind of I criticize. But I think that's not decisive. That's not. I think there's no inconsistency in saying, well, initially, of course, at some point in history, if there are no previous tradition of this, and there may be, if there's none, well, at some point, someone has to put the first stone, right, and start defining and making it more precise. But subsequent judges need to understand that they're in this practice of fashioning a more precise body of law, and not of sort of weighing things de novo in different times. And so my concern with proportionality is not so much that it's not that, well, it uses moral reasoning, and moral reasoning should never be used in judicial adjudication. Of course, it has to be used on some occasions. Sometimes even to interpret legal sources, you need to do it. But also, you could be at an initial moment where you just approve, we just got this new Bill of Rights, and we need to give specificity to it. But my problem with proportionality is that it makes that the rule, the systematic sort of method that will be always used. And if that's the case, then doctrine will not develop. That's my concern. That we will always be satisfied with this kind of precise, with this kind of open-ended thing, when we should be moving towards specification. It could even happen that we have the opposite. We go in the opposite direction. We value so much proportionality that when we had precise legal materials, we start sort of undermining them and applying sort of vague standards because this is more important. I think something like that's happening to some degree in British contract law with the recent Patel case. So my concern is that one.
discharge your burden, providing, recognizing what is the proper value of right. So you may run the risk of undervaluing right, but that's not the fault of proportionality. That's the fault of some other sort of mistake that might happen. So this one question that I did, like the moral level, and at the technical level, as far as I understood, your message was let's perhaps minimize or reject the proportionality test. Let's aim for more legal material. The more legal material we have, the more legal guidelines we get, less judicial discretion, more social coordination. That's the ideal world. But it doubts. More legal material equals more certainty, more social coordination, and so on. So this comes back. Perhaps you can clarify.
Yeah, exactly. Thank you. Yeah, those are both. Those are two excellent. Yeah, sure. Right. Interesting. So okay, let me start with this question. So thank you. Yeah, it's all very good questions and interesting. So the idea that proportionality is not, I mean, does not necessarily need to take a kind of a ministry of rights. I think that, I mean, I think that's true, but it comes at the price of adopting sort of the second. So that is what the authors of the second. But proportion is empty. It does not need to engage in this sort of more quantitative method. So if you don't like the quantitative method, then and you see it as a wrong, then it's a wrong of the cases. Some cases that use this flawed methodology, but it's not the flawed proportionality as such, right? And that's the sort of move I try to address by criticizing the two versions, right? Because it's a fair point to say, well, you are focusing. So there is this kind of landmark paper by Stavros Sakirakis, which I'm sure you know, right? It's Proportionality and Assault on Human Rights. It has a very provocative title. And he makes a critique of proportionality and makes sort of these similar claims that, well, rights are not being given due, and he focuses quite a bit on cases of the European Court of Rights. So Kai Moller, so in replying to that as well, could be, but the cases are, one could say that these cases adopted the wrong methodology of proportionality, and that's that, right? Like, so I try to, and I think that's a good point. So I try to first engage with those two versions. So say, okay, well, if proportionality is not going to be the maximization version, it will be because it's the kind of more open, and then it will be liable to other sets of considerations. And the other thing I try to do is, so that's why I kind of focus more on authors in this book. This book is kind of more about me engaging people. I mean, well, judges are people as well, but like authors name, not so much courts. And for common lawyers, that's some kind of, it's kind of a move that's more, well, not so natural for them. For civil lawyers, it's much more natural, right? We discuss with authors much more, but I choose to do it like that because I wanted very much to engage with the idea and not so much with a precise application, which could be, just the fault of some misapplication of the test or something like that. And also in the second part, in the sort of Berta part, I wanted to also associate some of the defects that we're seeing in proportionality. I mean, I want to at least raise the question that maybe some of the defects we're seeing in concrete course, maybe they have something to do with the openness of it. Maybe it's what we should expect, and it's not just like one thing. Maybe it's what we should expect. And of course, there could be other, as with all these things. Maybe you have materials that are kind of relatively flawed, but it happens that here you have just this amazing system of institutions that limit discretion very well, or this super developed legal culture that just. Well, then there could be other controlling factors, but I tried to kind of raise the question that maybe there's something in that kind of produces these faults, and that's why we're finding them. So that's kind of the try. Now, legal material. So yeah, that's something that's really interesting because I argue for more. Like in a way, I'm trying to say, well, more is better, right? So like, I mean, that'll be my slogan maybe by the end of the book, right? So more is better. But of course, it cannot be that. Right? Like, it cannot be just that because of course you can do it like as with all things, and you can do it wrong. So as I take the point that, well, if you have one method, proportionality, and that has to be discussed in its own right because of course a judge could do it wrong. The same could happen in drafting legal material. So, for example, one thing that could happen, happens very much in law, is that sometimes we have unnecessarily complex law, or we have sort of disorderly complex law. So we have a system of rules, exceptions to the exceptions, exceptions to the exceptions to the exceptions, and there is a point when the complexity is such that it's not clear what the law actually means, ceases to be coherent, and so there are contradictions and the like. And then you do have, you do have more, but in reality you have less guidance. You have less guidance because at some moment you did it kind of wrong, right? But so I take that, but I would say, well, but that's not a reason for leaving the enterprise of fashion. So our legal forefathers drafted codes, right? They thought you needed like a proper code of regulations. And I think even though sometimes like at least in my civil law course I remember sometimes people saying, well, Article 725 is not so clear how it engages with Article 7. So in Chile there's a massive problem with the inscription of property and how do you interpret possession. So that part is not very clear. And the rules are such that they are kind of contradictory and so on. So you do have a lot of rules, but they're not so clear. But still, that's not a reason not to try to engage them and do it properly. It'll never be perfect. But I think the enterprise of law and trying to say, well, we'll not settle for just one test. We'll try to fashion something more precise. I think that's something worthwhile, and it's important to try to do it well. And then comes a different set of questions of how you do it well, how do you, for Fuller's kind of thinking. From that regard. Yeah, sure. Yeah. So I mean, it's not that it's sort of. So I kind of associated with that, right? It's not that it's part of the 4 steps. Then it's that 5th step that says, cut the legal material. But I think there is something to. So if one says, well, we'll interpret proportionality as this opportunity, and this is the advantage of it, not a cost. It's the advantage of it that it allows to decide without recourse to legal material. Then that kind of moves towards the direction of simplifying. So then it's not casual. So Matthias Kuhn, sort of when he's stating this sort of view of this, which is very nice in line, he only mentions precedent and doctrine and the like in kind of one line as potential sources that could distort more recently. Right? So there's a problem. It's a problem that we have these things. And proportionality has the advantage of allowing us to overcome them and just thinking morally. So then it's no coincidence, I think, that when Kai Moller, a few years later, sort of develops this view, he's raising the question. Well, actually, we're talking about one test, a closed list of rights, few rights, but actually, maybe we can even do without the rights. Like we can even move towards greater simplification. And I think that's very much in keeping with the logic of this, right? So kind of, so then there is a question to say, well, why wouldn't you? Why would you prefer to have more rights? And I think you're moving that direction. Well, then kind of more development. I don't know. And then on legislature, right? The society only with pure legislatures, which yeah. So that's interesting. So I mean, so one thing so this is kind of one disappointment of the book, right? I don't have a sort of fully fledged moral plus technical theory of what rights should we have and what there should be, right? So what I have is so and also I think the argument of the book. So this is kind of my way of defending this. This is the way I defended it in my doctoral thesis when I was kind of challenged on these sorts of account, right? Because it's so you're criticizing things. Well, where does it move? How did it go? And I think what I would say is, well, if I'm right, so the thing is that if I am right, this kind of raises the stakes in terms of the complexity of the process. So then, so if one says, well, proportionality is I mean, what's the sort of say the nice feature of proportionality? That it's a one single test, which is kind of can be proposed and elaborated. If I say no, we should get rid of that. What we need instead is to grapple with each different right and each different circumstance according to the different peculiars. Then, well, to sort of propose a full alternative, I need to have like a deep moral understanding of every freedom of expression in the different realms in which it could be affected, and so this means advertisement and you can advertise for children or not, and a full version of that. Security, what things you can publish or not regarding national security, and so on. And then if I say, well, the right to privacy, well, all the things that involves from immigration to discrimination. So, and of course, I don't have a full version of that. What I do have is a sense of, what I have is a technical, so which needs to be filled up with moral categories. So what I would say is, what do legislatures need? Legislators need to start seeing that the task first, they need to grapple with fundamental rights, right? So that's part of the argument we make in this new book, Legislative Rights, is fundamental rights are as much an issue of legislatures as they are on courts. And in some theories, that gets sort of downplayed. And so we think, well, legislatures aggregate preference or realize whatever it's politically sort of viable, and then courts provide the filter of justice. And we very much want to resist that and say, well, no, actually, there's no reason why courts cannot think, legislatures cannot think of the whole range of relevant circumstances for the common good, and that very much involves rights, and they should, as part of the responsibility to grapple with it. And many legislatures actually have kind of human rights or fundamental rights commissions and so on. So they try to grapple with that. So I think first they should grapple with that. Second, the technical insight is that they need to provide guidance. So if I am a legislature and I am sort of in this new island, and we say, well, we need to come up with an idea of freedom of speech and how are we going to relate on that, well, we need to provide something more than just like a Bill of Rights saying, well, we will have freedom of speech. We need to provide something like a body of legislation regarding advertisement, honesty, honor, and so on. And then we'll have to start thinking in each of these cases, right? But we need to produce something else. I'm very sympathetic to Adrian Vermeule's idea, for example, of a codified content. So saying, well, like if Vermeule comes from a different direction, he's basically saying, well, legislatures have superior institutional capacities to deal with these issues. Now that's perfectly debatable, of course, but if it is so, he's saying, well, then we would like to have more from legislatures. So not just like, okay, they gave us a Bill of Rights and now it's kind of in the province of courts. We would like to have them, develop more and provide up legislation. And courts, on the other hand, when they see the legislature engage in these tasks and understand that this is as important for the fulfillment of human rights in a way that only the legislature could, then they should respect the work of the legislature, at least assess it in a different way as well. Absolutely. Okay, sure. No, yeah, that's all right. I have very bad short-term memory, so but it's okay. I'll ask back and get clarification. Yeah, I'm sorry about that. I provided too long answers. Yeah, okay. I'll try to be synthetic as well. Let me just start with and I'll try to be. Um, so let me start with the rule in the Constitution, right? Yes, that it does it make a difference? I think it should, right? I don't know. In some places it may make a difference, in others not. That depends on the party. But I think that's also interesting, right? That's also part of the way constitutions are framed. Sometimes they're framed as rules, so there's no reason not to apply it. And many times they are framed as relatively precise rules. So like already kind of doing the work, I think they should be doing. And when it's like when we already have that, I would say that's from the technical. So it depend. Of course, it could be a good rule, a bad rule. So then it should be changed. But from a technical perspective, in terms of ordering conduct and using it in the legal system, I think that's an advantage. It's an asset that if we have something that can be expressed in a rule, and of course not everything can be expressed, but if we have something that can be expressed in a precise rule, so we should use it like that. One example that is usually understood sort of as a rule in many cases, though some thought, but and more categorical is the right to torture, right? Torture and human degrading treatment, and sometimes that's develop street law a little more. I think that's an asset. And again, my concern is, well, if courts are too into the proportionality mindset, it could be that they use it as a principle that kind of reason. So I think there's some Chilean cases on due process of law, for example, that where our doctrine, not exactly the Constitution, but also partly our doctrine, treat things sort of kind of relatively well specified way that's not challenging, and we have kind of a set of rules. What constitutes a good due process? Courts have kind of used that in sort of the balancing framework. I think that kind of makes we lose the advantage that we had, and then puts the court in a kind of weird interpretive situation. Then on Alexian, positivism and not. I'm not sure I have an answer for that. I very much see this as a debate that's independent from the sort of question of what's the actual nature of law Like I'm not sure I grasp the connection so well. Maybe I don't know. Maybe you have thoughts on this. I don't know. Uh, I see this as separate debates. Something there's a caricature that's useful to dispel actually. So it's an interesting question because it allows us to sort of get this out of the way. Which sometimes sort of it's seen that on the one hand we have positivists that want sort of positive law, and on the other hand you have people that are whatever is not a positive these days. So natural lawyers who want more moral whatever, and actually that these things are separate, I think. So you can think that the only law actually is positive law, there's no moral, or think that there's actually like you need some kind of moral component, whatever this is. This come in different families, but and there is some connection between law and morality and so on. But in both cases you can think that sort of less law, more morality is better as a matter of sort of policy, or on the contrary, I think like it's very much needed to have precise legal materials and so on. And then, so what is balancing, what is proportionality in the relation between the two? So I'll just fall back to what I mentioned in the beginning, but it's tricky. I see that because it's not always clear what this means, and it's not fully independent of how one assesses it. So I put a caveat at the beginning of the lecture. Say, so for me, proportionality is this specific test that has these 4 parts. Now there's a variety. Like someone could say, well, in my country it doesn't have 4 parts; it has 3, or 2, or we treat it like a mixture of parts, like South African court, for example, famously kind of treated one. But I try to sort of methodologically sort of separate and say, well, proportionality is this test that kind of captures these 4 parts. I focus very much on the 4-part test, and of course, I'm aware that in some places you have different parts formulated differently, but they're substantially similar so that we can treat them under the same level. In other places, some parts are kind of conflated. So we say it has to be adequate to achieve a legitimate aim. So then the legitimate aim and the adequacy part are kind of mixed into, but they're really the 2 things going on, right? It's about how you formulate it. And some parts you have what I would call non-central cases of proportionality. So this is kind of what I present is kind of the central. In other places, you can have proportionality minus something. So in the UK, you had until the one case, you had, which is kind of the one that sort of articulated the 4-part test in UK law. You had a 3-part test that ended in the necessity test without the balancing. And I would say that's kind of a different thing, really, because balancing is very important. So I would say you can treat them under the same level, but you have to sort of clarify. And what is balancing? That's kind of the $1 million question, because I was intentionally vague, right? So you picked up on that, and I think it's partly because it's the formulations in law, in kind of case law, tend to be relatively open, and we have to look more deeply what exactly that means. And there we are in the realm of the theories of proportionality, which could be in present case law or not. Right? So on some accounts, it will be this moment where you actually do this sort of maximizing inquiry. In other accounts, it'd be this stage at which you kind of see whether the costs and the benefits are kind of related in a rational, reasonable way, whatever. And so that depends on the theory. Oh, I think yeah. I don't know. I think I get it. You will correct me if I didn't. Um, no. It's not confusing at all. I think. I mean, yeah. So okay. Let me start with that. Yeah. So that I mean, um, first, just as in terms of diagnosis, right? So there's this shared diagnosis that you can have bad, like you can have a plurality of legal categories, as I suggest, but they could fail as well, right? So there's no guarantee. It has to be done in the right way. I suspect that's not. I mean, it can happen because you have excessive quantity. I suspect it's not so much a matter of quantity, but of the way of quality, so to say. So the way they are framed, the way they are ordered. So it seems to me that usually when we have a body of legal categories that are specific but fails in guiding action, I suspect it's many times because we have sort of contradictions or it's kind of badly framed and so on. It can happen as well that we fail to guide action because it's too complex, right? There's just too much of it. That can happen as well. But I would like to raise that it could be because of that, but it could also be because of disorder. The thing with law is that we have legal specialists, right? So it's not something so we have legal experts that are supposed to be capable of dealing with great levels of complexity. So the amount of quantity that the system can tolerate in certain areas, and which are the areas that you can rely that will be mediated by lawyers, it's I think it's an important one. I think in other areas it's not like that because you expect the rules to be directly applied by lay people. So I think for example, some of our traffic regulations, it's more limited what you can have by way of rules because you want that to be applied directly by people driving, right? So you want to have overly complex rules in that regard. But in tax law, for example, well, that's something that tolerates sort of greater. So that's just by way of diagnosis, but I'm very much in agreement with that claim, right? Now, institutionally, how does this play out? Yeah, I don't mention in the book, but I think it's a really important question because, of course, you can have. I mean, it raises. I think it raises this institutional question, right? So which in this country or in this jurisdiction or with this institutional capacity, what sort of institutional interaction is more likely to yield a good body of legal categories in well order as we want. So there are a couple of things on that. So first, I think in many places, so I think it's not a coincidence that in many places we try to put the judiciary is hierarchical, and we try to put kind of this. We tend to think that the specially distinguished judges should be at the top, and in some sense, their ruling sort of binds what's going on below, and that can take different shapes. So, and I think that's very much sort of an institutional measure that we've taken to try to improve legal categories in the way they are applied by law. So if there is a contradiction, you can apply to the Supreme Court to provide like sort of uniform, and you apply not to just anyone, right? Because settlement could be provided by anyone. Right? Just one single person flips a coin, and there you have settlement. But we send it to the place where we've put our best people in theory, and I think that's sort of that's part of the logic of that is is try to respond to the sort of institutional concerns you raised. I think there's a good question here on legislatures and courts, right? So what should courts do? What should legislatures do? And sometimes we think of these issues only in terms of who is more able to get it right, who's more able to see the underlying justice questions and address it. But I think there's very much a question sort of in the line you say, who is more able to provide actual better guidance in this, right? So it could be that courts are more able to provide like case by case specific sort of just solutions, but bad at producing kind of an overall body of law that will be clear and understood and like, whereas the legislature maybe is more capable of providing something that's coherent and consistent. That's very much fact specific, but it kind of raises as well that question, right? The legislature has some kind of specific capacity, but the executive as well. It's kind of interesting to bring in play with us because the executive has very strong technical capacities. So in some areas that are very technical, so in my country, I think, for example, in anti-seismic, which in my country is huge, right? Like that's what keeps us all safe. Well, there you want a bigger role for the executive. So you want the legislature to provide some kind of broad ruling. You want the executive to provide all the details because they have the capacity, and you want the judges not to touch that because they don't have the capacity for that, and it's very technical. So there's huge stakes. So I think that's a really interesting question. I don't have a fully developed view, but I think it goes along those lines. Thank you very much. Yeah, and on so the degree of specialty and doctrine is low, right? I like that term. So a couple of things, right? So there could be genuine trade-offs here. Like it could be that there are situations where you say something along the lines of, well, we have a body of doctrine. It would be conducive to producing. I mean, there's a good in having a body of doctrine. It would be conducive to preserving this body of doctrine and to increment it if I follow it and just add it incrementally. But the change here is so big that actually a lot of this doesn't make sense anymore. And so it will be unjust, and there's been kind of a loss of epistemic value, right? So in the book, I kind of engage with this in relation to Adrian's Fermule take on the loss of epistemic value and the like. So that could very well happen. So it could be that you have a tradition of legal thought, but because of the change of circumstances, actually, so in general, a priori, you would say more tradition, more development, more epistemic value. That's in principle. It could happen that the situation has changed so much that actually the epistemic value has been decreasing, right? So then you could have a genuine sort of trade-off where you say, well, actually, here, if I depart from these rules, if the judge departs from these rules, well, it will be affecting some sort of rule of law considerations regarding the status of the parties and the way it should be bound by the law. It may set a dangerous precedent and the like. On the other hand, if it follows the rules, there be just and that's a possibility, right? I think we need to be aware to that. So I don't want to say, well, this is sort of always good, always works reasonably. But I think it's important to see the trade-off, right? That there is value in the body of law as well. It's not just like the value of justice. We're aware of it. There is value of that, and also I think it's important to acknowledge that many times we have these bodies of rules because they do have an epistemic advantage, right? So it could be that in some cases there is, but sort of the default position will say that they have a. Yeah, but it's a really question. Thank you. Great. Excellent. Excellent. So we said todo vale, but in the end, I think people have a great English and kind of dragged everybody to the English. And you have a very distinct English sort of accent, right? So well, I'll ask you later about that. Where that's going. Yeah, exactly. That's a kind of a flashback. So well, that's great. So let me go to the balancing formula. Yeah, so I kind of so this is the way I laid out in book and maybe appealing to you. So when we're talking about the balancing formula, this is kind of this formula that Alexei uses to express different considerations that go into the balance. And it's as any formula, it's formal, right? So you can, it gives you a lot of leeway as to what you can put there. Can it capture a special strength of rights? I think it can, but in a way that it makes it useless. So that's at least my take. So for example, the way that I think this plays out more clearly, or in the kind where the contrast is more stark, is with absolute rights. So can you plot absolute rights into the formula? Well, maybe. For example, if you attribute to in the abstract value of the right sort of like an infinite value, right? Now that is still it's not clear that can be actually expressed fully in the formula, because having an absolute value in the part of the right does not preclude that you could have an absolute value in the other side, and then there could be a stalemate, and so discretion. But that's not what absolute values are, right? But now, oh yeah, sure. A right that cannot be that doesn't allow for limitation, that cannot be derogated. So right, the typical, sorry, for example, the right to torture is sometimes seen as an absolute right. By that meaning that, sorry, the right not to be tortured, the right not to be tortured. Yes. Yes. Don't think badly of my country, right? If I talk about the right to torture, it's my fault. Exactly. In my constitution is the way Conrado expressed it, right? No, don't think badly of Chile. Like none of you will ever visit Chile anymore. Now, so that's something seen as an absolute right in the sense that there can no be a set of justifications that can make it legitimate to violate that right and actually torture someone, right? So you don't have in the European Convention of Human Rights, you typically don't have that second paragraph where it says, well, this can be limited, if it's necessary in the democratic society for the sake of all these other values. Well, with regard to torture, you don't have that, right? So can you plot that thing in the weight formula? I think not so well, because you can put an infinite, but then you have discretion, and also because sort of the weight formula, what conveys really, like you express it, you say, well, there'll be a comparison between sort of the overall importance up in the formula and what is overall below, and we'll sort of do that measurement. But I think that's not the way absolute rights work. Absolute rights kind of define a realm that just is never pertinent to compare whether its value or not. Now this is perfectly disputable with relation to the right to torture. Some people think that it's acceptable if the stakes are big enough. I don't think so. But if there is a right to torture, I think it's not aptly expressed in the formula. And then there's the risk that the weight formula could be trivial as well. So you do the moral reasoning on the side, so to say, and say, well, so you do not maximization, but just proper sort of reasoning about the strength of rights and so on, to avoid the rights critique to proportionality, and then you plot it in the weight formula. Well, then the formula is not doing work. So I think that we have the problem. But yeah, there's very much a question there. So thank you very much. And then yes, so is proportionality neutral? So I guess it depends on in what sense one thinks neutral, right? It's not necessarily neutral in the sense that, so I mean, on the first conception, which is kind of a more characteristic, it's not neutral in the sense that it's taking a position on what are the sort of relevant considerations that should be addressed. Now it's at a great level of generality. So I think it allows for some flexibility as well, but it takes a position. I don't think that's a defect of it, right? So I think that's actually a strength. The other one is more neutral, arguably because it raises also institutional questions that could be tied to substantive issues. But the other one maybe is more neutral, but I think that neutrality is comes at the price of emptiness, and so then there's a problem with that. Um, how to interpret free in the present constitution? Would proportionality be adequate for interpreting free? I'm not sure. I mean, no, actually, it'll be interesting what's your thought on that, because so I see proportionality as not that much in the business of interpreting. I don't know, like you. So interpret. So what's the content of free? What do we as a society mean to be free? Well, that in my mind that will relate to what are sort of the commitments that we have to this value and so on. Now, in doing that, we could kind of bring proportionality sort of in between and say, well, what we understand by free is what is proportionate, so what is not excessive in certain regards, and that would be a way in which I think it could be used to specify what's free. I'm not sure. It would be the primary way in which I would do, but it could be. I don't know. Yeah, that'll be in my account. Now, regardless of that, right? What I would say is it's it, it's possible that proportionality brings. I mean, in the first account, part of the strength of the first account is that it can provide specificity, right? It can promise that, so you can use it to kind of to start from more general principles and provide more narrow guidance in certain cases, right? So regardless of whether you frame that as interpretation or not, you could end up with that. So that's sort of if you're familiar with Alexi's sort of notation system. So he says, well, proportionality ends up with a conditional relation present, right? So you have a C, and then you know the priority of one principle over the other. The C are the conditions. So, and when you have that, you have actually something that has the structure of a norm, a fact description, and a legal consequence. The fact description is C, is the conditions under which a principle has priority over the other. The normative consequence is the principle that has priority in that case. So you couldn't. So that has the shape of a norm, and thus it can provide sort of some kind of intermediate norm. Now, what would be my concern there from a technical perspective, right? So this is instead of the objections that I raised to the other view, not to this one, because this one has specificity. I would say the C could be extremely narrow. The C could be so narrow that it doesn't really amount to a rule. I think there's some. I mean, that sometimes happens, and also what sometimes happens that courts assume that the result of the balancing will be a very narrow one, and thus in any new case we have to balance again. Even though that's not like logically required, but there's something to do. So in this euthanasia case that I mentioned in the UK, that comes up quite a bit, and the court saying, well, we did like this time, but next time do it in a different way. And formally, that's not necessarily the case. Like formally, you could end up with a different one, and maybe through like in within the interpretation process or in a different process, but you can end up with it. And yeah. Interesting. That's a legitimate question. Okay. Yeah. Mhm. Okay. Yeah. As to what is, yeah, that's a really, yeah, that's a really good point. Mhm. Yeah. Yeah. Sure. Mhm. Sure. Mhm. Interesting. Yeah. Thank you very much. Um, yeah. So in the difference in the concrete case and user review, uh, I mean, I'll take every restriction to proportionality, right? So, of course, in we do have a number of places where proportionality is used in concrete cases, and as you say, that may raise further problems because, of course, the sort of the sting of sort of the more ad hoc decision making is stronger when you have courts deciding specific cases through a method that they take to be very ad hoc, right? Even if that necessarily that wouldn't be like that, but the sort of the problems associated with sort of lack of rules and ad hoc decision making will be enhanced, and they will be diminished, of course, if one uses it only in judicial review. So I'll take it. Yeah. I mean, I'm interested that you call into question the second understanding, right? This is something so that's something I think about actually. I think about in these talks, but I think, yeah, I never voiced it because I'm a coward, but I have similar views. Like, I mean, or I don't know. I think there's a legitimate question, right? On well, what really counts as proportional? And I thought so this was my sort of solution because there are other views that sometimes are presented as part of proportionality, and I sort of my test, which is it's this methodological debatable thing, but sort of my test in the end was, well, we have this sort of four prong thing, three prong, whatever, but loosely, we have their set of requirements, and I will consider a conception of proportionality one that sort of takes advantage of those prongs to sort of propose to give an interpretation of them that does not render them into something that different, like sort of a test clothed in proportionality. So some people would say, well, actually proportionality is about non-discrimination, and so what you should do in the last events to address whether there is equality is ultimately being respected. And so I think, well, that's equality, right? So we don't need the four-prong test to get to that. I think that the second understanding of proportionality is kind of more of a limit case, a limit inside in the sense of saying, well, they are taking advantage of this four-prong test to do something that otherwise, or at least on their account, wouldn't be done, which is sort of allow for a kind of this open window, this window that you can open through this test. But it's always tricky. I mean, and this happens with many things in law and life, right? So I wonder. So I don't know if you guys know the old Batman, the Batman from the 70s, the kind of psychedelic Batman with Adam West, exactly. Yeah, Adam West, right? There's a legitimate question of whether that's really Batman, right? Like it's kind of all psychedelic dances, like it's colorful. That's so hardcore Batman fans say, well, that I'm not. It's not the Dark Knight, right? So there's always and this sort of, so is it real? So I'm happy to take sort of the second view of proportionality in that sense, and saying, well, it's proportionality in its own way, right? I mean, it's and it, yeah, it's not the hardcore field. So that's why I always kind of start with the first one as well, like sort of say, well, this is proportionality, and this kind of really keeps account of the whole logic of it, right? Whether I agree or not, but there's there a whole thing. And then I explained the other one more as a dialectical move to answer to the criticisms. And in moving, and in that move, one could very legitimately say, well, you moved so much that now what I say is you move so much that now you have nothing. But what other people could say is, well, you move so much that now you don't even have the name, right? And I think that's a legitimate claim. Oh, thanks to you. Great questions. No, thanks to you. These are great questions. Thank you very much. Oh, caipirinha, caipirinha. Anything but Argentinian wine.
Okay. Thank you very much.
No, thank you.